Labor and Industrial Law by MG Law. Now we will cover under Industrial Disputes Act 1947 main features of this act. Okay, on page number 16. Main features of Industrial Disputes Act. What are the main features, main provisions? Okay, main laws of the Industrial Disputes Act. Okay, so the main features, main provisions, or main laws are that any industrial dispute may be referred to industrial tribunal by the agreement of parties to the dispute or by the state government if it deems expedient to do so. So if there is an agreement between the parties to the dispute that the dispute should be referred to industrial tribunal, then it can be referred to it. Otherwise, if the state government thinks that it is expedient, it is necessary, it is best in that situation to send the dispute to the industrial tribunal, then in that condition also, in that situation also, the dispute can be referred to industrial tribunal. Next is the award or decision by the tribunals or the courts is binding on both the parties. Okay, the decision or award is binding on both the parties to the dispute, and it should be enforced by the government. The government has to enforce it. Next main feature is that the strikes or lockouts, they are prohibited during the pendency of conciliation and adjudication process. Okay, during conciliation process or adjudication process, the strike and lockouts are prohibited. No one can do the strike or lockout during the pendency of settlement reached in course of conciliation. Okay, in the course of conciliation, if there is the settlement is pending, then at that time also the strikes and lockouts are prohibited. During the pendency of awards of industrial tribunal declared binding by government. Okay, during the pendency of awards or decision, like the decision of the industrial tribunal is pending, at that time also the strikes and lockouts are prohibited. Next main feature of the act is that in public interest, the appropriate government has the power to declare any industry as an public utility service. Okay, so in public interest or during the time of emergencies, the appropriate government has the power to declare any industry as a public utility service. The normal, in comparison to normal industries, the control of government on public utility services is more. Okay, so during the time of corona, the government declared the banking industry as a public utility service. So the unions and the workers of the banking industry, they were prohibited from doing strikes at that time. Okay, it can be done for maximum 6 months. Okay, it can be repeated after that, but for one time it's 6 months. The industries like transport other than railway, because railway is itself a public utility service. Okay, a public utility service, you can say, like utilities means necessary essential service for the public, like the power supply to your house, water supply, these are essential services. Okay, during corona time the banking industry also came under public utility services. So the transport sector other than railway is itself a public utility service. Coal industry, cotton textile, food stuff, iron and steel industry, these can be declared a public utility service by the government in the public interest. Next, the provisions are given for the compensation by employer during the time of layoff or retrenchment. When the worker is laid off or there is retrenchment, how the compensation and how much compensation should be given by the employer, the provisions are given in the act. The provisions are also given about the compensation at the time of transfer or the closure of the industry. Okay, authorities are provided for settlement of industrial disputes. Okay, In the Industrial Disputes Act, there are certain authorities that are provided so that the industrial disputes can be settled. These authorities are Works Committee, Conciliation Officer, Board of Conciliation, Conciliation Board, Courts of Inquiry, Labor Court, Industrial Tribunal, National Tribunal. So all these authorities help in the settlement of the industrial disputes. These were the main features. Let's have a quick summary. So what are these? That the industrial dispute can be referred to the industrial tribunal if both the parties agree or the state government thinks that it is expedient or necessary to refer it. The awards or decision of the tribunal or court are binding on both the parties. They are enforced by the government. The lockouts and strikes are prohibited during the pendency of conciliation and adjudication proceeding, settlement reached in course of conciliation, or during the pendency of awards of or decision of industrial tribunal. In the public interest, appropriate government has the power to declare any industry as a public utility service. It can be done for maximum 6 months, like the transport sector, coal, cotton, textile, food, iron, and steel. During the time of layoff or retrenchment, there are provisions given how much compensation should be given by the employer to the employee or worker. The provisions are also for compensation during transfer or the closure of the industry. In the Industrial Dispute Act, there are authorities provided for the settlement of industrial disputes. These authorities are Works Committee, Conciliation Officer, Board of Conciliation, Courts of Inquiry, Labor Court, Industrial Tribunal, and National Tribunal. So these were the main features of Industrial Disputes Act. If you are interested in this PDF for revision, okay, you can get the link in description or comment box. Next topic will be industry, which we will cover in next video.